Thank you very much, Ewan. Now, the Oscar Pistorius trial heard crucial testimony on Friday as the state challenged the double-amputee sprinter over why his girlfriend had failed to scream before and during the moments he shot her through the toilet door. Now, let's take a quick listen to an excerpt.
Of your whole version, Mr. Pistorius, this is the most improbable. Riva at that stage is 3 meters away from you in a toilet, and she never uttered a word.
That's correct, my lady.
It's not possible. It's not probable. She would be scared. She would shout out and talk to you. You in the same room.
My lady, I agree with Mr. Nall. She would have been terrified, my lady, but I don't think that would have lent her to scream out. I think that she would have kept quiet for that reason.
Mr. Pistorius, you're now in the room, you're shouting. She's 3 meters away from you behind that particular door. There is no way that you'll convince a court that she stood there saying nothing. She wasn't scared of an intruder. She was scared of you.
Advocate Gerrie Nel there in his cross-examination of Oscar Pistorius, and a cross-examination that has earned him the nickname the Pitbull by many out there. Now, with us in studio this morning, William Booth, Chairperson of the Law Society's Criminal Law Committee, to give us a bit more of his expert insight on the case thus far. Now, William, we'll touch on the fact that he's been called the Pitbull and all, but let's talk about the fact first that lots of people are saying that Mr. Pistorius has not done himself any favors in the way that he's gone about this cross-examination. The answers he's given, sometimes even accusing his own legal team of not always giving the right advice, the right kind of answers. What would you say to that? Has he strayed a bit off what his legal team have prepared him to say?
Well, I think I must agree with that, because they've had months and months to have prepared, and they knew what type of questions the prosecution was going to be asking. And I would have assumed they would have run through this as kind of a mini trial beforehand.
Yes.
So the answers that he's giving seems to indicate that he's kind of carrying on his own and not maybe according to how he's been prepared. And having said that, obviously being prepared doesn't mean that other people are telling him what to say, but just advising him from a legal perspective how he's going to be cross-examined and what are the crucial aspects that the prosecutor is going to be going for. You know, he's contradicted himself. He seems to have strayed from the facts that he set out in his affidavit during the bail hearing. And in my mind, one very important aspect relates to the actual shooting, where 1 minute he says he acted in a conscious manner to ward off an attack or an imminent attack. The next he says, well, he can't really remember pulling the trigger. And the next he actually says it's an accident. Now, those are really 3 different situations, and he kind of moves from the one to the other.
Yeah. So obviously this is going to play a huge role in the decision by Judge Masipa at the end of the day, but I mean, we heard it just now where Advocate Gerrie Nel said that he doesn't believe, or it's very improbable that Riva would have been silent when Oscar was 3 meters away screaming, and of course the shooting was going on. So, you know, can Judge Masipa's decision be based on the probability? Because the facts that are coming out from Pistorius' testimony and the cross-examination are clashing.
Yes, I think his explanation is, well, that he didn't hear if she shouted, because of the firearm and the noise and the loudness thereof, and his ears were ringing. But instead of saying that, he actually initially says she didn't scream. Instead of saying, well, look, I really don't know, she could have. Maybe she did, maybe she didn't, but I didn't hear it.
How does that play out, though? Because there's been many instances where he would perhaps give an answer and then come back and say, but oh no, this is what I meant. How does the judge weigh that kind of decision up in trying to determine at the end of the day whether that is truthful or not?
Look, the judge and the assessors at the end have to decide on his credibility. Is he a reliable witness? And the test is his evidence false? His evidence has to be reasonably true. So even if the judge says, actually, I don't believe you, in my heart of hearts, I don't actually believe what you're saying, but I can't find that your evidence is false. Only when she says the evidence is false, then can his evidence be rejected. But she's got to look at all these facts, the way he's answered these long, rambling answers, and then kind of coming back and trying to explain, and he's kind of going off on a tangent of his own, and not answering. If he just stuck to the questions and answered them, because if he's telling the truth, surely you can be asked 100 times the same question, and you're going to answer it in the same fashion. Or his defense should say, hang on, that question's been asked and answered, let's move on.
Yeah. William, thank you very much. Please stay with us. We're going to be chatting to you a bit later on again. Intriguing stuff developing in the North Gauteng High Court. Of course, the resumption of the court case this morning at 9:30. You are also welcome to follow more in-depth analysis of the trial at www.sabcnews.com. We'll be back with you after the short break.